The Honorables, the presiding Chief Judge and Judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court.
Good morning and welcome to our virtual Court of Appeals here. I am Judge Donna Stroud, the presiding judge for this panel. And our panel this morning, we were sitting in the courtroom that you can see behind me in the background. The judges would be sitting beside me, and we would have Judge John Airwood on my right, and I believe Judge Darren Jackson on my left. And so we have one case for argument this morning, and that the case is DiPrima v. Vann, and I believe everyone is ready to proceed. So let's see, we have the appellant, Mr. Middlebrooks.
Thank you, Your Honor. May it please the court. My name is Gil Middlebrooks of the Mecklenburg County Bar, and I represent appellant C.B. Vann. Grace DiPrima, who was the plaintiff in this case, and C.B. Vann are two teenagers who, beginning in 8th grade, went to the same private school in Charlotte for students who have learning disabilities or other academic difficulties. They were very close. They used the term, quote unquote, bestie, a teenage term to describe each other. Testifying about the late fall of October 2019, Grace DiPrima testified that at that time they were in fact best friends. As I hope that you will agree, a Chapter 50C case that involves two teenagers as the protagonist should have caused the trial court's antenna to go way up and to realize that this was not a run-of-the-mill domestic violence kind of case that district courts see all the time. This case started because the DiPrimas in late October 2019 invited C.B. Vann, Grace's best friend, to come with them on a family trip to Gatlinburg, Tennessee. It's that trip that led the DiPrima family to seek a civil no contact order under Chapter 50C. And that trip was the primary focus of what happened at the hearing, which was a one-day hearing held on January 31st, 2020.
Mr. Middlebrooks, the appellee has argued or has posited in their brief that you have not, or your client, I know you did not try this case initially, that your client's lawyer did not preserve the issues with respect to things happening outside the state of North Carolina, nor the age of whether the sufficient age was raised at the trial. How do you respond to that argument that that's not a preservation and not something we should consider?
Thank you, Judge Airwood. That's a great question. You're right. Trial counsel did not object. The problem for the appellees in this case is that that's not like hearsay coming in. The age element and the fact that the offense must occur in North Carolina, the conduct must occur in North Carolina, are statutory elements. A defendant cannot give a trial court subject matter jurisdiction by waiving those kinds of elements. So the fact that there was no objection is meaningless. Those are elements under the statute. This court has to consider them just as the trial court had to consider them. In broad terms, there are three major elements that a plaintiff must prove to obtain an order under Chapter 50C, and it's our contention that the trial court erred in all three areas. First, the plaintiff must prove stalking, as that term is defined in the statute, which includes both intent elements and impact elements as defined in the statute. Secondly, the statute requires that the offensive conduct must have occurred in North Carolina. And third, it requires that the defendant must have been at least 16 years of age when each act was committed. We contend that the trial court erred in all three areas. First, I would like to address the intent issue that infects the entire order that the court issued. Stalking, as defined in Chapter 50C, has the following elements that include subparts. First, there has to be more than one occasion. Second, the conduct either has to be following or harassing as defined in chapter 14 in a specific section. And most importantly for this case, there has to be evidence and a finding of intent to either place the plaintiff or somebody reasonably close to her in reasonable fear for their safety, or intent to cause substantial emotional distress and actually have caused substantial emotional distress. In Ramsey v. Harmon and St. John versus Brantley, this court made clear that a trial court is required to make findings not only that the defendant harassed the plaintiff, but also that the harassment was accompanied by intent to cause that specific harm. Two separate findings are required. Not just that the defendant intended his conduct, he knew what he was doing, he knew that he was saying those words, but he intended to cause the harm that the statute covers. That's a very specific issue of intent. Here,
why can't we read the trial judge's findings and say that the intent is implied, or that they don't have to make that particular finding, but intent is subjective, and so the court has, by saying there was a violation, the court has found intent as by implication.
Two matters that apply to this case, Judge, in response. First, there has to be evidence in this case of intent from which the trial court might, even under your scenario, might infer the intent required by the statute. For this case, it's important to note that at the close of the case in chief, as all defendants do, trial counsel made a motion to dismiss. And one of the arguments trial counsel made was, you didn't put on evidence of intent. So even Judge Arrowood, in your scenario, the argument there was there's nothing from which the trial court can infer evidence of intent because the plaintiff did not put it on. Here's what Ms. DiPrima's counsel said about that contention. Quote, I think the most relevant thing to point out is that a 50C is not based on what the defendant thinks, what he intended, and what he meant by this. That is blatantly wrong as a matter of black letter law. And this court, in multiple cases, has said that the plaintiff must prove the intent. Now, we believe that the trial court is required to make a separate finding of intent for each act that it considers to be unlawful conduct. We think the AOC form misleads trial judges in this, and that if a trial judge had the statute in front of her, she would have gone through and said, okay, I need to make an intent finding here, an intent finding there. So the closest that the trial court comes in this instance to making a finding, and I think Judge Arrowood, this gets to your point, is at the start of her order, which is on record at page 15, she says, quote, the defendant has been intimidating and harassing the plaintiff by the following actions, colon, close quote. And then it goes on just to list the actions. That's a blanket statement. Now, the question, if I'm sitting where you are, is, isn't intimidating enough? I would suggest that it's not, and here's why. Think about the word intimidating. It means to frighten or overawe someone. Sometimes the word intimidate can mean can describe purposeful, intentional action, but it is just as easily used to describe the recipient's reaction rather than the actor's intent. A person could intimidate somebody with his size or voice without having any intent to either intimidate somebody, or more importantly for this case, to put them in reasonable fear for their safety, or to cause substantial emotional distress. In my career, many lawyers have been told that they can be, quote unquote, intimidating when they put on their lawyer voices. A large man turning a street corner late at night might be intimidating to a smaller woman waiting at a bus stop without meaning to. And you can intimidate somebody without the intent to cause them substantial emotional distress. That's the problem with the word intimidating in this case. It doesn't tell us what the specific intent that the statute requires was there or not. And the plaintiff has conceded effectively that it did not try to prove intent. Now, context is king. I will admit that. In St. John, this court okayed a finding of intent based upon the word intimidating, but it was in the context when the defendant started his conduct after he learned that the plaintiff was going to be a witness in a criminal case against him. The evidence of his actions and the context in which they were taken showed his intent to cause her substantial emotional distress or to put her in reasonable fear for her safety. But this court can, and I urge you, should reject the use of the word intimidating in this case. And I hope for all cases, because it's a word that carries too many meanings if we're not specific. And as lawyers, boy, we should be specific. I would hope that you would direct that the AOC form be changed so there's a specific section on the form where the judge has to write his or her findings about specific intent, or at least check off that says, A, the defendant intended to place the plaintiff in reasonable fear of her safety, or B, the defendant intended to cause substantial emotional distress. Why that finding, a specific finding, is crucial could find no better illustration in this case. First, as noted, plaintiff's counsel did not believe that Chapter 50C required such evidence, so she chose to offer none. Second, as I noted above, context is king. This transcript and the exhibits are replete with exchanges between Grace and CB that might trouble older adults, but fall well within what teenagers consider normal today. Two mental health professionals, CB's psychiatrist and psychologist, both testified to the fascination with first-person shooter games and dead baby jokes that is the norm for teenage boys, and they both emphasize the importance of considering context. Two examples, I think, illustrate the concept that I'm speaking of. First, in response to questions about her own comments to CB, Grace was asked, well, now, Grace, you're complaining about things that he said, but you're telling him at the same time that you want to kill your parents. And she goes, well, that's only a joke. That's a teenage thing. Teenage thing. That was the term she used, and I think aptly can describe this whole case. The problem with the plaintiff's case in this view, in this line of argument, is they presented absolutely no context. In describing messages that CB and Grace exchanged, where both of them spoke of suicide and deciding which high mountain to jump off, something that might have alarmed older adults like me, she admitted that CB ended the exchange with, quote, okay, love you, bestie, close quote. And then she said, quote, love you too, close quote. So this, in their context, is passing for the everyday dark humor that teenagers often get involved in. What the record reveals is two teenagers who exchanged text messages, phone calls, and conversations that in the most part showed that Grace gave as good as she got in terms of content. In the light most favorable to her, there are messages and conduct from CB that troubled her because she believed he wanted more than just a friendship. But there's nothing in the record to show that CB acted with specific intent to put her in fear for her safety or specific intent to cause substantial emotional harm. The
Mr.
record
Middlebrooks.
does.
Mr. Middlebrooks,
Yes.
I'm sorry. I had a question. The pictures and some of the things in our record didn't copy terribly well, but I just wanted to confirm what I think it looks like. Just one of the things was the comment regarding the I guess hanging the Harry Potter characters, and it looks to me like the picture of these they're like cartoon characters, it appears, not like actual people. Is that
They are
correct?
people. It's hard to tell, Your Honor. You're referring to a message that Grace sent to CB on November
Right.
8th, 2019. It's hard to tell from the picture whether it's a drawing or little figurines. It almost looked to me like they were hanging off a Christmas tree branch.
Yeah, I mean, they
But
don't
it's
look
not-
like actual people. I mean,
That's
as
right.
best I can tell from the, I
They're
mean, you know,
caricatures.
and I just, given the descriptions of it, when I saw it, I was, you know, I sort of expected it to be actual people, but looks like cartoon characters to me. So
It
anyway.
is some kind of caricature. You're right, Your Honor. The record in this case shows that C.B. Vann, the only evidence with regard to his intent came from his psychologist and his psychiatrist. And they talked about C.B.'s lack of social skills, the fact that he presents more like an Asperger's student than neurotypical, that he has problems deciphering context, social space, and physical space, and that his comments were made in many instances in a joke fashion to engage with Grace. There was absolutely no evidence at all to counter that. There was no evidence from the DiPrimas about the context of what did CB look like when he said X? What were his mannerisms, etc. So the court's case law requires the plaintiff to prove and the trial court to make this separate finding that there be intent either to cause a person to be in reasonable fear for their safety or intent to cause substantial emotional distress. Now, as Judge Arrowwood pointed out, there are cases that infer that the finding on this issue, that the finding can be inferred from a more global statement like the intimidating one. If that latter view is to prevail, I would urge the court to disavow it and require specificity. Because something along the lines of the defendant intended to cause substantial emotional distress. Now, in the past, and maybe in this case, the court will be forced to review both the stated findings in the order, and at most it's that one word intimidating, and the underlying evidence of intent to see if it will stand. Sometimes that's easy to assess. If you go out to your car in your driveway every morning and I show up on my property line with a snarling, raging pit bull and stand right at that property line 5 feet away, and I do that on a repeated basis, there's evidence of context there. If, as in St. John's, the defendant starts harassing a potential criminal witness right after he learns of what her role will be, then the context is very suggestive, which means it is easily provable, but it is the plaintiff's duty to do that proving. So, and then beyond the intent, if the case is one about substantial emotional impact, the court has to look at the impact. Pulling back that curtain here reveals that there was absolutely no evidence offered of CB's intent by the plaintiff. And on the defense side of the case, clear evidence that CB did not intend to cause Grace any harm or to place her in danger. Take, for instance, the bit of conduct that I'll talk about on the Tennessee trip, the play fighting incident that's in the transcript. The DiPrimas complained that Grace and her mom were play fighting outside and that CB tried to get in the middle of it. You take a boy who doesn't understand social clues, not mature, presents as an Asperger's kid, how do you find intent there? It's simply not there in this record. So I believe and urge that this court follow what it said about the plaintiff having to prove intent. That was the Tills versus Willett case, which the plaintiff expressly avowed that she had not done here because she didn't think it was required. And secondly, just as importantly, that the trial court make a finding that is specific, A, as to intent, and B, as to the resulting harm. The error in this case of letting the matter go forward past the plaintiff's case when the plaintiff said, I didn't prove intent because there was no need to, they compounded the error in the order, as I said, because the AOC form doesn't help trial judges. And I think this is an opportunity for this court to provide better guidance to trial judges in the future. Because of the trial court's error on the intent issue, we are going to ask this court to vacate the order and use this as an opportunity to clarify what a finding of intent must say, and also to clarify the forms. I'd like now to turn to my second issue, which has to do with conduct outside the state of North Carolina. In the complaint that the DiPrima filed, it is monopolized almost by this early November trip to Gatlinburg, Tennessee. The parents allowed Grace and her younger brother each to invite friends. Grace asked if she could invite CB. Her parents said yes, and the son was allowed to take a friend of his own. Just as the complaint made this trip to Tennessee its primary focus, the hearing focused largely on the Tennessee trip. That trip was the foremost in the court's order. There is no evidence of in-state North Carolina conduct in the early November 2019 period. The court led with it in its findings and returned to it at the conclusion of its findings section. I think it's significant that the trial court began order with that trip and ended with that trip. Section 50C2A1 requires that the conduct at issue, not alleged impact, occur in the state of North Carolina. While Chapter 50C does borrow part of the stalking definition from a section in Chapter 14, the jurisdictional scope of Chapter 50C is more narrow than that of Chapter 14. Chapter 14 allows a court to consider out-of-state conduct that has an in-state impact. Chapter 50C does not. It says the offending conduct must have occurred in the state of North Carolina. There's no evidence of unlawful conduct in early November outside the Tennessee trip. So the trial court committed clear reversible error in this instance by considering what happened while the two teenagers were on the trip to Gatlinburg with the DiPrima family. Again, I think this is a partial fault of the AOC form rather than a judge following the statute. If there had been a section for the judge to check that all the conduct took place in North Carolina, that would have helped the trial judge, because in many, many cases, that is not an issue. In this case, it is. That November episode permeates the trial and resulting order. It's clear reversible error, and the court should vacate and reverse. The final issue I'd like to address is one of age. This is a mixed question of fact and law, as I said in our brief. As part of its definition of unlawful conduct, 50C17 requires that the defendant be 16 years of age or older at the time each such act of unlawful conduct is committed. The age of the actor thus becomes a statutory element of the case, without proof of which the trial court must rule in favor of the defendant. Here, there are no specific findings that CB Vann was 16 years of age at the time of each of the acts that the order lists. Because it's an element of the offense, however, the trial court cannot make assumptions as to this. Moreover, in this case, there were several red flags that should have alerted the trial court. First, the complaint as styled is brought by Grace's mother against CB's mother. A trial judge should have looked at that and said, well, that's really odd. Who's claiming the wrongful conduct? Who's my real party and interest here? Now, that never got cleaned up in the record, but the trial court apparently viewed this as a case of one high schooler, Grace, against another high schooler, CB. But if nothing more, the complaint itself signals that this is a case between two young people. At trial, there was no direct evidence of when CB Vann's birthday was. The testimony was that on January 31st, 2020, he was 17. It didn't say when he turned 17 or when he did not, just that he was 17. The complaint lists only two time periods in 2019 when he could have been 16 or 17. It mentions, but it does not mention other times in 2019. And it does not mention the 2018 acts that find their way into the order. The order lists 3 2019 periods, the Tennessee trip, and then dates in June and October 2019.
What was the test? Can you refresh my recollection as to what the testimony was with respect to when the respondent gave the appellant the birthday present?
There was no testimony, Your Honor, as to when Grace DiPrima gave the present to CB. The testimony was that in late October 2019, the DiPrima family went to Florida, and while in Florida, Grace bought CB a lightsaber, which she characterized as a birthday present. But there was no evidence as to whether it was a late birthday present, an early birthday present, or on-time birthday present. The only direct testimony are statements both by Grace and CB that as of the date of the hearing, he was 17 years old.
All right, Mr. Milburn, I just note you're at your, had you reserved 5 minutes for rebuttal?
I did, Your Honor, and I'll eat up a little bit of that as I close out.
Just want to make sure you saw that. Okay.
I did. Thank you very much.
All right.
The complaint lists times in 2018. The court cannot, I'm sorry, the order lists times in events in 2018 that were not alleged in the complaint. Now, assuming the standard rule that the complaint conforms to the evidence adduced at trial, with which the trial counsel for CB didn't object to, nevertheless, it still remains an element of Grace DiPrima's to prove that he was 16 at the time. The math doesn't work, and the trial court cannot assume that. So for that reason, at least the 2018 dates go out of play. I'll reserve the balance of my time. Thank you, Your Honor.
All right. Thank you. All right, Ms. Watts.
Good morning, and may it please the court. I'm Rebecca Watts, and I represent the appellee Grace DiPrima in this action. And I'm going to go through the issues in the same order that Mr. Middlebrooks did. So I'm going to start with specific intent, and I'm going to start with his example of a large man rounding the corner.
Ms. Watts, I'd like you to start with telling me why Ramsey versus Harmon doesn't require the judge to find specific intent when it says, and I quote, "This statute requires the trial court to further find defendant's harassment was accompanied by the specific intent to either A, 1, or 2. And I've looked, I don't see any findings about specific intent in this order.
You're right. There is not a specific finding that uses the words specific intent. What our position is that specific intent, his intent can be read into the findings that are there. That if you required the trial court to make word for word findings of every part of every element, you would have a trial court having to find that defendant engaged in knowing conduct through these means that was directed at plaintiff, that tormented, terrorized, or terrified her, that served no legitimate purpose, that placed her in substantial emotional distress. There are so many subparts in 50C and stalking and harassment to require the exact words to be used are far beyond, obviously, what can be on a form.
Ms. Watts, Ramsey doesn't say you've got to find all of those things, but it does say that the court further find specific intent. Does it not?
It does. It does. And our position is that the court's findings about CB's behavior do show that he had specific intent.
Well, Ms. Watts, as I read the, looking at even the argument before the trial court, it was mentioned before, with the attorney talking about that it's based upon her subjective intent. I mean, certainly as far as emotional distress, yes, let's just assume that it caused her severe emotional distress for purposes of argument. But on the other side, we've got his intent. And the argument was, as Judge Airwood pointed out, that, well, you don't have to find that. You just have to find that, that he intended that, or that he meant to do that, but that's the effect that it had on her. I mean, is that an accurate characterization of the argument that was made to the trial court?
I believe so, yes.
Okay. And I
Um,
understand you weren't the attorney making that argument, so.
right.
Today is National Be Kind to Lawyers Day, by the way, so,
Right.
you know.
I saw that this morning.
So,
There is a difference between somebody feeling intimidated because that's how they feel versus somebody doing something with the purpose of intimidating. You know, the woman at the bus stop may feel intimidated just because the man is large and looks angry. But if he walks up to her and says, "If you betray me, I will kill you," or "Will you blame yourself if I kill myself?" and then sits in class or sits on the bench with her and tries to cut himself with a knife, she still feels intimidated, but she feels intimidated because of what he did. This child may be a teenager and they together engaged in dark humor and joked about wanting to, jump off bridges or mountains or fight with their parents. But that is different than somebody saying, "I am afraid my best friend is pulling away from me and I'm going to do what I need to do to keep her." And that's what he was doing. He was using his threats to keep her attention as his friend. That is him making a choice to behave in a certain manner to get a certain result. That is specific intent. I agree that, hey, let's, fight our parents or let's kill ourselves together is not specific intent to cause her distress. But I will kill you if you stop being my friend. And then I see you talking with someone else and I cut myself while you're watching. That is a pretty clear message that I am doing this.
Ms. Watts, so of course, there was an extensive evaluation done of this situation by the school, evaluation by therapists, psychologists, psychiatrists, a school, which is obviously on high alert and wanting to protect students, doing an investigation to determine if there was actually any concern for harm. And they determined that there was not, based upon the evidence presented. So, and obviously kids, say things to one another, again, in that context, where you've got a situation where there is this extensive investigation done of these comments, and the people who know them, they have determined that there was not a specific intent for any sort of harm. Although certainly the actions were disturbing to Grace, no doubt about that. Where do we find specific intent by the defendant?
So if someone evaluating him makes the determination he was never going to do it, there was no actual risk of harm because he would not have hurt her, I think that can certainly coexist with him telling her, "I'm going to do this if you do that." He is using his words to cause her to behave a certain way. She does not know that he would not actually harm her if she stopped talking to him. And in fact, when he did things, she would go back to being attentive to him because it did its job. His threats, his self-harm did their job to bring her back to him. And I think that can coexist with a mental health professional saying, but he actually never would have hurt her.
Well, let me ask you too something about the location of the conduct, because we know a lot of the findings deal with things that happened in Tennessee,
Right.
and then some in North Carolina. And so we've got several things, like I said, in Tennessee, a little bit in North Carolina. If we assume that a court can only base an order on things that happen in North Carolina, how do we determine, it's sort of like how much is enough to have subject matter jurisdiction in North Carolina?
To qualify under the stalking statute, there just has to be more than one incident. So more than one incident would be sufficient. But I'm not starting from a position of assuming that all the activity has to take place in North Carolina. That is not how I read 50C. 50C-2A does say that to initiate the action, you have to be the victim of unlawful conduct that occurs in the state. So as a threshold, something has to have happened to me in North Carolina for me to file my action. That's the only place in 50C that talks about action or conduct within the state. In the definition section, 50C-1, the definition of unlawful conduct does not say conduct that occurs within North Carolina. 50C-5A on relief says upon finding a victim has suffered unlawful conduct committed by the respondent, the court may issue an order. There's nothing in there that says finding that unlawful conduct committed within the state of North Carolina. So nothing in there actually says all of the action has to have taken place in North Carolina.
Do any of the actions have to take place in North Carolina?
Yes, I believe some of the actions have to take place in North Carolina for you to have threshold ability to bring the action. And I kind of compare it with what 50B is. 50B focuses on where I reside as the potential plaintiff. I can file here if I live here, no matter where the conduct occurred. 50C, oddly, does not require you to be a resident to file here, but requires something to have happened here unless you get into 50C-2A2, where an adult is bringing on behalf of a child. The adult has to be a resident here. So the focus, 50C in North Carolina having an interest is, has something happened here? Not as all of it happened here, something happened here. Whereas 50B is, are the people here, is the plaintiff here. And as Mr. Middlebrook said, in the stalking statute that 50C borrows from, does allow prosecution for stalking as long as at least one of the incidents occurred in North Carolina. They can prosecute stalking of incidents that occurred outside of North Carolina. And yes, the jurisdiction part of the stalking statute, which is 14.277.3A subsection E, of course, that was not incorporated into 50C, but I think that is a good thing to look at. If we are treating stalking in something other than a criminal manner, if we're treating it in a civil manner, in a criminal matter, they intend to be able to reach things that happened outside of North Carolina, as long as something happened in North Carolina. And that is how I read 50C, especially since the unlawful conduct that occurs in the state, that qualifier is only in the section of the statute that deals with what has to have happened for you to even bring the action. So I think
you're layering, it appears to be several interpretations here, and assuming I would agree with you for sake of argument that you don't have to find intent, but that you can infer intent from an action. Does the action from which you could infer intent have to occur in North Carolina?
In other words, does the main piece of it, the heart of it,
Or
have?
does the action in which you're saying you can infer intent from these things that happen, does the thing that you can infer, if I had intent, then you don't have to find it, which I'm, for sake of argument, making this hypothetical. If I agree with you on that, does the action that from which you can infer intent have to occur in North Carolina?
I would say yes, because actually I think all of the incidents, each separate one to qualify as stalking, there would have to be an intent element. So I think all of them would have to have intent, which that is the ones in North Carolina are where he is threatening.
So you're not saying that you can infer intent based upon the whole series of actions that the trial court found here. You're saying that the trial court found in each separate action the trial court listed here that there was intent. Is that what you're saying?
Yes, I think that's what I'm saying, that each incident of each conduct has to be with the intent to qualify for to qualify for the definition of stalking. And move a little bit to the age issue. If we know that CB was 17 on January 31st, 2020, then we know that he was 16 at least by January 31st, 2019. Which means everything in 2019 would be while he was 16. He could have been 16 before that. I don't know. He could have been 16 in the fall of 2018. But we know, because he was 17 at the end of January 2020, that he must have, even if his birthday was that day, he must have been 16 at the very end of January 2019. The trial court has findings in November 2019 that he repeatedly followed and touched her without her consent. Those are some of the actions in Tennessee. Then in June 2019 and October 2019, he threatened suicide. In October 2019, he threatened to kill her and physically harm her if she crosses him or if she stops being his friend. In November 2019, he told plaintiff he wanted to fight her parents. There's enough that happened during a time that nobody can dispute that he was 16. Additionally, we have Grace or her mother filing for her a verified complaint. When you have a verified complaint, the allegations in this complaint can be treated as an affidavit and they're evidence. The trial court had evidence before it of his age because she alleged it. She alleged that he was at least 16 when these things happened. Now, if he wasn't, he could have put on evidence that he was not 16. But she did put on evidence because she put it in her verified complaint. And I agree that any findings about things that happened before he was 16 cannot be the basis for a 50C order. So the findings in there about anything that happened before he was 16 can't support the 50C order. But I also, the way that I read a 50C order, because it is a form and it's very short, everything's just on front and back of a page. It has a checkbox where it says plaintiff has suffered unlawful conduct by defendant in that, and then there's space to type things in. The fact that defendant has committed unlawful conduct or that plaintiff has suffered unlawful conduct by the defendant is really more of a conclusion of law, and it's actually in the conclusion of law section on the forum. So everything typed in after it, I read as the findings that support the conclusion of unauthorized conduct. And they're not numbered, but if you can, if you take each sentence as a separate finding of fact, you can kind of rearrange it in your head like you would a regular order where there are numbered findings of fact and then a conclusion of law that there have been acts of unlawful conduct. Looking at it that way, so long as there are findings that do support the conclusion, then the conclusion is based upon competent findings. There may be extraneous findings. There may be.
I don't see many periods in her order.
Oh,
I see a lot of commas and semicolons.
there are. So you kind of would have to, I guess, at each semicolon, kind of treat that as a separate sentence. Yeah, kind of treat a semicolon as a period. Yeah, it is quite a long, highly punctuated sentence, incorrectly punctuated sentence. And could the forms be better? Absolutely, they could be better. There could be more there could be checkboxes for all of the sub elements, and that would be wonderful. Every now and then the forms are tweaked. I mean, I think the most current one, or at least the one that was used in this case, was revised April 2017. So perhaps it does need to be revised. And I know that using a form order does not excuse the trial court from having to make the findings they need to make. But I think if you read all the long paragraph after in that as separate findings about what he did, there are more than enough in there that are even assuming it can only be based on things that occurred in North Carolina. There are enough findings there of things that happened in North Carolina that he did intending to cause a certain behavior from her, and that happened during 2019 when he was unquestionably at least 16 years old. So,
Ms. Watts,
yes.
let me ask you sort of I guess this is sort of a broader question, and you may say this is not something we should be thinking about, but we have to think about these things sometimes. So this, of course, happened in the context of a school.
Right.
And the order has the effect of basically saying to the defendant, you cannot attend this school.
Right.
To a certain degree. I guess nowadays that we're remote, that's another question, and we won't go there. But anyway, so where this, so the school itself, or let's say, and this happened in Charlotte, an area with a lot of schools. But what if we had a situation in a rural county where there aren't other schools, and this was a private school, but if it was a public school, and we have an order, and obviously lots of things happen between kids and schools, and some of those things are really truly intimidating and harassing, where essentially a child is shut out of a school, and the state has an obligation to provide an education for this child. Should we be concerned about that?
Yeah, I actually, my personal opinion is that it is too broad to lock somebody out of the entire school. And the Fletcher School, my understanding is a fairly specialized sort of school. It is not just the regular public school you go to based on where you live. And so I mean, I will agree that having CB not be able to go to school there, it's probably beyond what is necessary to give Grace a 50C. I think they could certainly say can't be within so many feet, and then leave it up to the school to help arrange their class schedules where they're not sitting in the same classroom together, or if they are, just for necessity, if they have to take the same class, the teacher is keeping them on separate sides of the classroom. No, I think it would be a tremendous hardship for a high schooler to say you can't go to your high school anymore and you have to go a different one that you're not districted for. And good luck working with CMS to figure out how that's going to work with no bus transportation from your home and all that. So I think that part actually is too much, to have him banned from the school completely.
Well, let me ask, since we're talking about schools and students and specifically students who are going to the Fletcher School, which I believe there's evidence that it's children who need special needs to some extent.
Right.
The fact that you're dealing here with two children or two young adults, but who are teenagers who are special needs children, how does that play in the fact that the burden on the trial court to find specific intent? If someone has special needs, does that not put a heavier burden on the trial court to find specific intent as if you're dealing with adults and you make a finding?
I think it probably does. I mean, with any teenager in general, with parts of the brain not being as developed and impulse control not being as developed, and then take the special needs on top of that, certainly. And I think that's where you get to differentiating the dark humor, the teenage things that are okay, that in my mind are nowhere near okay and wouldn't have been okay when I was a teenager. You know, talking about committing suicide together or guns and knives and hanging Harry Potter characters. That doesn't feel okay anyway, but even with a teenage brain and even with a special needs child, there's a line, I think, beyond which some action has to be taken, because special needs and teenage brain isn't going to stop somebody from acting on a threat. It's a threat they may not have made if they had been 10 years older or didn't have special needs, but there's certainly, I think here has gone beyond, has crossed the line into something where something needed to be done.
But why doesn't that put the burden on the court to find this, even if I accepted your version that you can assume intent when you're dealing with this situation like this, why doesn't that require a more specific finding, specifically after the language in Ramsey?
Right. I mean, ideally, that language would be in there. Ideally, there'd be a checkbox for it. But I do believe that certain findings include the intent element. I think the findings here include intent element.
Ms. Watts, as I recall, and I'm not looking at the statute, so I could be wrong, but I think some of the definition of stalking and whatever also refers to a criminal statute, for part of the definition. And since North Carolina has now raised the age for a criminal prosecution under those statutes to 18. So we've kind of got this little gap here where 16-year-olds are still being looked at under that definition. I mean, how does that figure into it? This is something that he could not be criminally prosecuted for based upon his age, at least as an adult. Obviously there's the juvenile system, especially where we're looking at this intent issue. And obviously one of the big parts of the raise the age legislation was the fact that the teenage brain is not fully developed and they don't have a full appreciation for some of the results of their actions.
I had not thought about that before, but it'd probably be a good idea to amend the 50C statute, which I know is outside the scope of what we're doing here. But no, I agree with you that a 50C statute probably should be amended to have an 18-year-old cut off instead of 16 for along the same reasons as the criminal statutes with raised age. Absolutely. And that's, maybe that's something you can figure out how to get the General Assembly to look at doing, to line, because it is 50C is civil, but I know everybody 50B, 50C is civil, but has quasi-criminal-ish sort of elements and results from it. So yeah, probably now that the criminal age has been raised, we should raise it in the 50C statute as well going forward. Yeah. Well, unless your honors have any other questions, I think I've covered everything that I wanted to cover.
Yes, rebuttal. Oh, I think you're muted. Still can't hear you. Nope.
How's that?
Very good. Yes, we can hear you now.
I apologize. Don't know why. I'd like to make 5 quick points in rebuttal. First, I think this was in response to a question that Chief Judge Stroud raised about what the lawyer meant in response to the motion to dismiss. And Ms. Watts, if I heard her correctly, went along the lines of, oh, yeah, the lawyer is saying that you can infer intent. That's not what happened. On page 145 of the transcript, the trial lawyer for Grace DiPrima says, I think the most relevant thing to point out is that 50C is not based on what the defendant thinks, what he intended, and what he means by all this, any of this. This is all based on Grace's subjective intent. As I stated earlier, that's wrong as a matter of law. Ms. Watts also stated that one of the pieces of evidence was that CB sat next to her in class and cut himself with a knife. I urge the court to look carefully at the transcript. I do not remember such a scenario happening. I do remember discussion of him one day sitting across the class from Grace and pushing a ballpoint pen into his arm, but nothing in class with a knife. The court asked Ms. Watts about the statement along the lines of, if you cross me, I will kill you, that he wanted to control her. Ms. Watts answered that question by focusing on what Grace felt, the impact. She did not address the intent connected to that statement if it were made, because there is no evidence from the plaintiff of that intent. The only evidence was the discussion from the testimony from the CB psychologist in which they discussed that comment, and CB explained he and Grace were joking around and she gets him. She understands him. That was the only evidence of his intent. As to harm in that same time period, the October 2019 time period, the evidence clearly shows that she asked for a break from him from 2 weeks. He honored that break. She reinitiated contact 2 days later by showing him a video of her fostering puppies. That's when they went out to movies, said she was best friends. So even if you get to impact, you've got some impact questions there. Finally, Judge Arrowood asked about the special needs thing. I think that should be taken into account by the plaintiffs in their case. In the public school setting, when a special needs student acts out, there's a process called manifestation determination, where a team decides whether the conduct was a manifestation of the kid's disability or whether the kid intentionally committed the conduct. Here, the statute requires intent of putting a person in reasonable fear of safety or of the substantial emotional distress. Not that he volitionally did the act, but it has to be the intent behind the act, and there's no evidence of that here that would support even a global finding by the trial court. Finally, Ms. Watts talked about you have to do something with this threat. Well, my response is 50C orders are not the answer to fix all problems. And there, in fact, was substantial evidence in this case that the DiPrimas initiated the 50C action only when the school said we weren't going to suspend him or expel him from Fletcher. The point being, if you're going to use 50C, you must prove 50C, each of the elements. And the trial court is required under Ramsey and progeny to make those findings of specific intent separately from findings of harm. We ask that you vacate and reverse the order. Thank you very much for your time this morning.
All right. Thank y'all for your arguments. Very interesting. And we will end the session now.
Thank you.
Thank you, Your Honor.
This session of the North Carolina Court of Appeals is now adjourned.